Is that correct up on, what's your phone say here? What's your phone say, Skip? Mhm.
1:58.
Okay, welcome everybody. Looks like we've got about 2 minutes before we get started. Good to see Judge Hargrove. Good to see Karen Bailey with us as well. And we also have Ashley Dixon with us. And let me see, I know that I have heard from Judge Harris, who intends to be here, Judge Nora Haynes and Stephen Kelly briefly. The folks who are joining us from Savannah are battening down the hatchet. They're getting ready because it's going to be a rough ride. Hopefully not too rough for them in the next little while. Let's see. Karen, you doing okay?
I am.
Good. And where are you today?
Me, Cumming, Georgia.
I'm in Georgia. Somebody told me yesterday that Cumming, Georgia has the highest per capita income in the state of Georgia. Is that true?
I've heard that too recently. I think if it is, it's something of recent origin. So it's
Okay.
growing.
We have Judge Harris joining us. Judge Hargrove, we appreciate you taking a break from the bench to be with us. You have a busy day up there?
Absolutely.
You don't have folks in the courtroom right now, do you?
No. Oh, no. No, I don't do that.
Oh,
I
boy.
really do have to set this time aside for this.
And we really just can't thank you enough for doing so.
Absolutely. Thank you for having me.
Let's see, we've got, okay, still waiting for a few more people. Be run and get my phone and remind a couple of people that we're here, and I'll come right back. Okay, Nora requested that we send her the link again, which we're doing.
Or Jenny's that you just were doing.
Once Nora joins us, we'll have a quorum and we'll be able to begin.
I have a question. Can I share? I've tweaked my PowerPoint. Can I share my own?
I did the same thing. So
I'm pretty sure that you can share your own, but only one person can share at a time.
Yeah.
Is that correct?
Right,
Ashley?
right, sure.
Yes, that's correct, Judge Amiro. Only one person can share their screen.
Okay, thank you.
I can handle that.
Lynn, can you please send Stephen Kelly the link again, please? Judge Kelly in Savannah. Just got a text from him indicating he's trying to join.
He could be like me. I was trying to join using the live stream and all of a sudden realized I'm on the wrong one. So
Okay. Well, hopefully all of this will be corrected shortly. The good news is we have a shorter meeting than usual. Allocated an hour. We'll try to get everybody out in an hour, and I think we can still do that. And I've spoken to Dr. White, who's unfortunately not going to be able to join us today. He's got another commitment that he just can't move. Well, I saw Stephen Kelly pop up there for a second. Nora's saying that won't let her on. Why is that? Ashley, do you have any idea why this would be preventing Nora from logging on?
I do not. Is she entering the password that's attached to the email? I mean, the invite. It includes the link to the Zoom meeting as well as the password.
she just texted me as well. I just told her to make sure she's on the right meeting and not on the live stream.
Okay, looks like we've got Steve Kelly with us. And so that gives us a quorum, myself, Judge Harris, Dr. Bailey. We have Judge Hargrove and Judge Kelly. And so we've talked about Judge White, and Nora's joining in just a second. So why don't we just go ahead and get started? This is the Behavioral Health Reform and Innovation Commission Subcommittee on Involuntary Commitment. It's our virtual meeting. And our speakers today are Dr. Karen Bailey and Judge Sarah Harris. And hopefully everybody's received a copy of the agenda as well as the two handouts. You should have a handout from Dr. Bailey that's entitled Outpatient Commitment, Past and Potential Roles in Treatment in Forensic Mental Health. And also a presentation from Judge Harris entitled Involuntary Outpatient Commitment. It's my understanding that they'll be sharing the screens with a couple of small revisions. We really appreciate you being here to join us this afternoon, and I'm going to jump right in since our time is limited. Dr. Bailey?
Okay. I'm trying to see how I share my screen. Do I hit share screen? Okay.
Judge Amaro, I'm sorry to interrupt. I'm getting texts that the live stream is not working or people aren't allowed in on the live stream. I don't know if there's a problem there, but I just wanted to identify that.
Thank you. Ashley, any thoughts on that?
Yes, let me contact the media services to see if the live stream link is working.
Okay, we'll just hold until you give us the thumbs up that things are working there. We obviously want everybody who wants to participate to be present.
Can you see my screen?
Yes, looks great.
Okay.
All right, well, Nora is with us on the phone, so we'll add her to the list of people present. Thank you for being here, Nora. Hope that you're being safe where you are. Thank you for being here, Nora. Hope that you're being safe where you are.
I am resending the link to the live stream now to the distribution list, so the public should be able to join and get the notification.
Thank you for being here, Nora. Hope that you're being safe where you are.
I am resending the link to the live stream now to the Judge Amiro. We are all set. I resent the live stream link, so the public should be able to join now.
Okay, I'll just say it again very quickly. Thank you for joining us. This is the Behavioral Health Reform and Innovation Commission Subcommittee on Involuntary Commitments virtual meeting. It's an hour-long meeting. Our guest speakers are Dr. Karen Bailey and Judge Sarah Harris. Dr. Bailey.
Okay. The title of my presentation is Outpatient Commitment, Past and Potential Roles in the Treatment of Forensic Mental Health. I hope I don't lose my voice. You may wonder why I use the word outpatient commitment rather than assisted outpatient treatment, which is the term in vogue now. It's just more to emphasize that we've had outpatient commitment in Georgia for many years. And so it's nothing new, although the new statute updates it and facilitates it. It's always been a part of Georgia. In fact, Georgia Forensic Services has been using outpatient commitment for over 30 years. At present, there's probably about 300, probably 350 individuals with the forensic status that are under outpatient commitment today in Georgia. The interesting thing is that outpatient commitment in Georgia is primarily achieved through the superior and state courts, less so through the probate courts. We've used the probate courts way like 30 years ago, and it moved more to superior and state courts. I think one of the opportunities we'll be discussing today is to make more use of probate court to be able to expand outpatient commitment. For those of you who don't know what forensic services is, it mainly involves two types of individuals involved in two different kinds of situations. One is individuals who are incompetent to stand trial. These are individuals who have been charged with a crime, but are unable to participate in their legal proceedings because they do not have either a factual or a rational understanding of the proceedings against them, or they're unable to work with their attorney in their own interest. The other population that's involved in forensic services are those individuals who have actually entered a plea that their mental state interfered with their ability to be responsible at the time of the crime, and the trier of the fact, whether it's the jury or the judge, has confirmed that, and they were found NGRI, or not guilty by reason of insanity. The not guilty by reason of insanity population in Georgia is fairly stable. Not that many people are found NGRI every year. People think it's there's a huge number. It's a very small number, maybe 10 to 15. 10 to 15 people are discharged into the community from our state hospital system as NGRI. So it's a small, non-changing population. So therefore, the population I really want to talk about that outpatient commitment can have an impact on are those individuals who are incompetent to stand trial. This is a growing population of people. It is nationally a growing population, a topic of much discussion on how to deal with folks who are found incompetent to stand trial. So that's the population I'm really talking about. So for those of you, this picture so I can see, for those of you, I'd like to just walk you through what happens to someone when they're found incompetent to stand trial. So initially, the attorney will raise the issue that someone is not competent to stand trial and bring that to a judge. If the judge believes there is merit to that, the judge will issue an order for a competency evaluation. When an order is issued, it goes to either a licensed psychologist or a psychiatrist who specializes in forensics to do an evaluation on the person's competency. Once the report is done and the evaluator opines, about 80% people are opined to be competent. So they actually just go to court. That's what that arrow on the bottom is sort of sending you to. But about 20 to 25% are opined not competent to go to trial. So they have a hearing, and then generally the court, after the hearing finds that they are not competent, the court then issues an order for restoration. Generally, when a court orders an order for restoration, they can go outpatient, but generally they go to a state hospital for restoration. Almost all, very, very large percentage. When they go to the state hospital for restoration, about 75% are restored to competency, some years closer to 80%. Those people, that's the other arrow, go to court and proceed with their legal situation. For the 20% that are still not competent after restoration, they are generally inpatiently civilly committed to a state hospital and will stay there until they no longer meet inpatient civil commitment, which is a danger to self or others. And then they are released to the community. So this is the general scheme of things. I want to show you how I think that outpatient commitment can be used earlier in the process to avoid hospitalization and institutionalization for many people and to keep people in the community longer. So there's 3 points of where we could divert people using outpatient commitment in this sequence. And so let's start at the beginning, because the beginning would always be the best, early in the sequence. So the first place that we could intervene is after the court orders for an evaluation, before the person is found incompetent to stand trial. There is a very big window for diversion right there. And the question that needs to be asked right then and there is there an intent to prosecute this case? Because what we have seen, when I was forensic director years ago, we saw many cases that the state worked, they were in a state hospital, we restored them to competency, and then the court dismissed the case. So it didn't sound like the court really wanted to prosecute, or the prosecutor didn't really want to prosecute. And a lot of energy and time was put into making someone ready to go to court, and then the case never happened. Another consideration is the length of time for restoration. Restoration in Georgia, you have 90 days is your initial period, and then you get another 9 months to restore somebody to competency. So that's a year. Generally, restoration takes about 120 days on average. Sometimes by the time a person gets to the hospital to get services for restoration, it's 6 months. If the case only is going to be a sentence for a year, does it make sense to spend all this time trying to restore somebody to competency when your sentence is going to be less than that? The other considerations in initial diversion is there's a lot of state resources that go in it. People stay in jail. Many judges keep people in jail before they can be restored to competency, until they can be restored to competency. And then they spend a long time in a state hospital system. So a lot of state resources go into restoring someone. There's also a huge cost to the defendant. If you are taken out of the community for a year between jail and the hospital, you're going to lose your housing, you're going to lose your job, and you may lose contact with your social support system. So these are reasons we might consider diverting if we're not really going to prosecute and the intent is not for the person to go into the penal system. One thing that's often not recognized is that competency restoration is not the equivalent to treatment. So when a judge orders competency restoration, the state, who generally performs the competency restoration, is focused on helping the person understand their legal situations and be able to function adequately in their legal situation. They are not really as worried about teaching the individual how to deal with their symptoms in the community. So it doesn't really further their treatment in the long run. It is very focused on legal. And I think sometimes when people order competency, they don't realize the difference between the two. So that's one of the reasons to think about diverting at number one. If, however, there is intent to prosecute, and then you would move on to restoration. So you really do want to restore them because you really do want to prosecute, you really want to have a legal proceeding. So then we would move to stage two. Right now, when you order restoration, there is the availability of outpatient restoration. So you could do a outpatient commitment for outpatient restoration rather than to be restored in a state hospital. By statute right now, that is limited to a nonviolent offense. However, there's two case law cases from 2018, which say it's a much wider range of cases that can be done. Regardless, it is not used that often by judges. I'm not clear on why, and it's some reason we need to talk about why don't we use outpatient restoration? Why are people being restored in a hospital rather than outpatient? What would make sense, and what is done in other places as well, is that first it should be a clinical recommendation. Clinicians should say, yes, this person needs to be restored in a hospital. We have to have the structure of the hospital setting. The person may need involuntary medication. That can only be done in a hospital setting. But the clinician in the report could also say, no, they don't need inpatient. We can do this on an outpatient basis. Those recommendations can then go to a judge who then would look at the safety considerations and bond considerations and decide whether it can be done inpatient versus outpatient. Right now in our statute, there is the possibility, which is very rarely used, which is very confusing to me on why people don't use it. You can do You could do inpatient restoration for a short period of time and then follow it with outpatient restoration. So instead of keeping an individual out of the community for 90 to 120 days to 6 months, they could go in the hospital for a week or two to begin medicine. And if they do well, the restoration could continue outpatient. This is a benefit to the state as far as resources, but it's also a benefit towards the individual, again, so they don't lose employment, housing, and social supports. This is very ideal for low-level offenses, particularly misdemeanors. In many states, misdemeanors do not go to it's not permitted in some states for them to go to the hospital for restoration. In our state, that could very well happen. You can always go to the hospital for treatment, but it doesn't have to be for restoration. So they can go civilized. It doesn't prohibit somebody from going for treatment. It just prohibits them from going just for the purpose of restoration. And it would work as well for low-level felonies. So let's proceed. So let's say if a person does need to go to the hospital for restoration and they are found incompetent, then the last part is there's some people after a year cannot be restored to competency. And that's what we call people who are non-restorable. Non-restorable individuals are generally civilly committed to a state hospital. And at some point, the hospital will say they no longer meet civil commitment and they should go to the community. And generally that switches from an inpatient commitment to an outpatient commitment. So we are already doing that. That's many of the 350 people that I talked about initially. But what could be different? We could use probate court here. These cases continually go back to the Superior Court, sometimes for 10, 15 years. I think that we could use probate court for more minor cases and also for cases that are continually going back to the Superior Court after 10, 15 years. It would free up some of the resources for Superior Courts and allow the probate court, which is in the person's community, to be more involved and connected. And we could expand the use. So basically, in summary, I think if we used outpatient commitment more in Georgia in forensic settings, we could match the intensity, the severity of the situation with the level of resources we're using. Right now, we're using high resources for cases that don't have that kind of severity. That would free up higher level, more intensive, more expensive resources for individuals that need that level. There would not be a wait to get those if we put people who didn't need those levels more into community resources. For individuals, the earlier we do the diversion along that line that I showed you, the less stigma for them, the less they're involved in the criminal system, and the more they're involved in the civil system. And again, the earlier the diversion, the more likely an individual will be successful. Again, I can't emphasize enough, the longer you put somebody in an institution, the more likely they are going to lose their job, their housing, and their social supports. I'm done.
Karen, let us know when you're ready for questions.
I'm ready.
Can I just go back to the third slide for a second? The one.
Do you want me to put the slide back up?
Yeah, it's the flow for defendants who are incompetent to stand trial.
Wait, let me get back, go back and share. I lost the sharing part. This one?
Yes.
Okay.
I'm getting a lot of different information about how long it's taking to go through this process. I mean, if you have an incident that occurs today, and then somebody's arrested and brought to the jail, and they don't make bond, for example, do you have any measure of the length of time it takes from the date of arrest to the date that the court signs an order for a competency evaluation?
So I don't work for DBHDD anymore, but actually the DBHDD wouldn't have that information from the time the arrest to the time the court signs it.
Right.
Would
And
be in a court's database.
So the DBHDD would not have that information.
They could probably construct it. It would be, you'd have to go through records, but it's not, they are not in DBHDD's realm of knowledge until a court order comes to DBHDD.
The next segment is from the time of the order to the time of the report. I had heard from someone recently at a conference that the amount of time it takes to go from the date the judge signs the order to the date that the forensic report is issued is about 103 days. Does that sound right?
I don't know what it is current, especially with COVID and all that. I don't know what DBHDD's data is. They could give you what it is on an outpatient basis.
DBHDD. And then there's the next segment is the judge signs an order to restore for some percentage of these people.
Mhm.
And you're saying that percentage is about 20 to 25%?
No, what I was saying is of the percent, when judges, yes, about 20 to 25% are opined in the forensic report not to be competent and to require restoration if the legal process is to proceed.
Okay.
And my point was we should divert some of those folks, but.
I'm just starting kind of with a baseline here. And so 20, 25% potential need to be restored if in fact the state decides they want to pursue the charges, right?
Correct.
Next, I think that there's a bit of a gap here that a lot of folks don't know about, and I'm wondering if you believe it still is true, that there is frequently a several-month wait in a local jail between the time that that the forensic between the time that the court orders restoration and the time that they make their way into a state hospital for restoration. Is that generally true?
It's absolutely true. And that's one of the reasons I'm trying to stress. I think we need to make sure that all the people that are ordered to go to a state hospital actually need their restoration in the state hospital. I think we over rely on the state hospitals for restoration. In many parts of the country, it's done outpatient and in other settings. So there is a significant wait. And so that's one of my points is I think we can use outpatient commitment to send the appropriate people to the state hospital, and those that don't need the state hospital for restoration, if we could take that segment out, then I think the flow will go much quicker.
So 103 days plus 10 months waiting to be restored. Then when you go to the state hospital, it's more than a year, correct?
I don't know what the date is right now, but it is quite a way from the order to restoration. Again, that's the point of, can we pull some of these people out for outpatient?
And I don't disagree with that. I'm just trying to make sure that I understand the severity of the problem.
Mm-hmm.
I've heard 10 months in jail before they get into the state hospitals, and I've heard lesser periods of time, but DBHDD should have an accurate number there, wouldn't you think? Yes,
DBHDD could give you that number.
Okay, and then you have this group of people, and then let's say, for instance, after 9 months, you have somebody who's not restored. At that point, then it indicates that the person becomes civilly committed, inpatient. But isn't there also an opportunity to have somebody outpatient, civilly committed as part of that same statutory scheme?
Yes. And that's where I had the 3, but yes, we could do it now, and we need to make more use of that. Absolutely.
And is there a category of person that is not restorable and also doesn't meet the inpatient or outpatient civil commitment criteria?
Theoretically, yes. Theoretically, yes.
Is that theoretical, or is there a segment?
I did it for 30 years, and usually if you're found incompetent to stand trial and you're not restorable, I would think you're going to qualify for outpatient commitment. Just because your mental, to get into that situation where unless you have family or you have a guardian, I think you probably need some structure. But definitely not necessarily inpatient civil commitment. I think many individuals will do well with outpatient civil commitment. And that's where you see people coming into our system with very minor charges repeatedly, and where I think outpatient commitment could make a difference.
I have just a couple more questions. I'm going to open it up. The next is, I think that you're referring generally to this notion that misdemeanants are sometimes in some states not permitted to be restored to competency by that state's department. Is that true?
Well, I wasn't necessarily saying not restored to competency, but they don't use a hospital setting to do that. Some states don't restore to competency, they drop charges, but what I was referring more to is an automatic inpatient hospitalization for a misdemeanor is unusual.
In Florida, do they have a statute that does not permit a judge to sign an order to restore to competency a misdemeanor? Do you know?
I don't want to quote Florida exactly. I believe the charges are dropped in Florida, but I'm not an expert on Florida law, so I don't want to quote it, but I believe in Florida. I know they don't go to the hospital system, but I do think that the charges get dropped after a certain point in time. But
how do you feel about restoration to competency of misdemeanors? Do you think that's a good use of inpatient resources?
no, I don't, because I think by the time, like I said, we've seen so many cases, by the time they are restored, the charges are dropped or the year sentence would have been over. And generally those folks, and talking to many state court judges really just want to get the person on a track to help. And they just want them not to be repeat offenders in their courtroom. And the way you're going to do that is not through competency restoration. The way you're going to do that is through outpatient commitment and connecting them to providers in the community.
Yeah.
So, and I think most state court judges are very supportive of that. Now, there may be some cases that don't fall into that really do need to be prosecuted. But I would say the bulk of cases, when you talk to state court judges, they are trying their hardest to get the person treatment and trying to get them so they don't are repeat offenders in their court, but they have no mechanism to do it. So they use competency. But I really think what they want to use is outpatient commitment.
That sounds right to me too. Let me ask you another question, and this will be my last one, I'll open it up, is, well, actually, I understand that you have worked in the department for 30 years and that you have actually in the past done a little bit of work trying to speak to state court judges about diversion of this category person. Do you recall making such presentations?
Yeah, I along with somebody from the department talked with state court judges last October about diverting cases, and state court judges were very interested and very positive about doing that.
Do you have a specific program in mind that in a slide deck that you could share with us?
I don't right this moment, but yeah, we had done a presentation for the state court judges with DBHED suggesting that they could use a sort of different kind of order that sort of suggested we're not really interested in prosecuting this. So the solicitor in court had to be on board for that. And we really want to know what our options are for treatment. And could we order treatment instead of going down this prosecution route? And judges were very, very supportive of that. I mean, they really just, like I said, I just felt like they really wanted to get defendants treatment. They wanted them to stop the cycle of misdemeanor crimes and showing up in their courtroom. And they just didn't know how to go about getting that. And so often they asked for competency. And they didn't really realize that when they asked for competency, the report and the whole focus was not really on the kind of treatment they were thinking of. So.
Well, I see we've got 3 diversion points, and it would be great if we knew exactly, if we fleshed those out and showed people how to divert. and how to divert to these outpatient services. Is that who do you think would be the best group of people to focus on that type of an effort?
Well, me and Judge Harris talked. I think we thought that, a group you would need, I think you need someone from prosecutor solicitor's office, you need defense attorney, maybe a judge, definitely a representative from DBHDD, and maybe the sheriff's department. I think that group could come up with something.
Seems like a great idea. If does anyone else have anything for Dr. Bailey before we shift over to Judge Harris, who will be able to continue that conversation?
Judge Amaro, I do want to add, since we're talking about this, and I've got Dr. Bailey here, I have read a lot about diversion evaluations. So instead of a forensic evaluation, and I'm not sure what the differences are, but doing a diversion evaluation at the nearer to the beginning of a case. So I know you're looking at entry points once it gets to the forensic request level, but even sooner than that, having a possibility, particularly I'm talking about misdemeanors at arraignment or some point early in the case.
Why not first appearance?
First appearance, right. Could you, because I am thinking maybe not in the very, very large courts, but at least in many of the courts, you're seeing the same people. These judges are seeing the same people over and over and over again. So they are certainly well aware of who they are. And if there would be an entry point even before the ones you've identified.
Okay, well, that all seems like worthwhile work to be doing going forward. Dr. White, I saw that you have joined us. Thank you for joining. I know that you're very busy and we appreciate your time. Is there anything from you or from Judge Kelly or from Judge Hargrove related to this presentation made by Dr. Bailey?
No, not at this time.
All right, thank you. Judge Hargrove?
No, I don't have any.
Okay, let's shift over then to Judge Harris, who can give us her quick overview of the involuntary outpatient commitment.
All right. Well, a lot of what I'm going to say is fairly similar to what you've just heard, but I'm going to talk about the civil involuntary outpatient commitment. And I'm referring to it this way because that's the way it's identified in the code, and that's the way we've known it for many, many years. And I would just echo what Dr. Bailey said. This is a process that's been in place for a long time, but not really well used in our current system. I think it's important first to recognize that there are two different procedures. There is criminal involuntary inpatient outpatient commitment, and there's civil involuntary outpatient inpatient commitment. And they're separated, and that's a distinction that's important to understand. So to begin with, I think going through the definition, our new definition of outpatient is important because we need to think about what type of situation we're dealing with. So outpatient now means a person who is mentally ill and who is capable of surviving safely in a community with available resources, support from family, friends, and others, and who is, based on their psychiatric condition or their history, is in need of treatment in order to prevent further disability or deterioration that would very predictably result in dangerousness to self or others. A lot of these misdemeanor cases we're talking about, you fall right into this category. And whose current mental status or the nature of their illness limits or negates their ability to make an informed decision to seek voluntarily to seek treatment or comply with the recommended treatment. So we have broadened the definition of outpatient. The court has a number of options, and the way that we normally see these cases right now, if we see outpatient at all, is through a petition for involuntary treatment and or outpatient treatment. So the court has two choices, or has three choices actually: order involuntary inpatient treatment, which can only last for 6 months; order involuntary inpatient treatment followed by outpatient treatment. And all of that treatment, inpatient plus outpatient, can't exceed 1 year. It can, but there's another process for that. Or they can order involuntary outpatient treatment. Well, why then don't we use, or haven't we used, outpatient treatment? Well, the court has to take into consideration these things. Is outpatient treatment available that meets the service plan, the individual service plan for this person? And will that person likely obtain the treatment so as to minimize the likelihood of them becoming an inpatient again? Many communities don't have accessible outpatient treatment. And what I mean by that is a good support system, services that are provided within their immediate community. It's not to say that a community doesn't have outpatient services. They may just not be in that county. So if you have a person who needs transportation, who needs someone to get them to and from their treatments and their appointments, and they live in Dooley County, and Dooley County doesn't have the kind of services they need, they have to drive them all the way to Columbus. And it isn't reasonable to expect that a person who's suffering from a mental illness may by themselves be able to attain those services. So we have to consider that. And there has not been a push to try to meet those problems. And we've got some Band-Aids, but our immediate services are very crisis oriented. So the procedure for involuntary outpatient commitment. First, there's the procedure for a community mental health facility. So the community mental health facility has a person that comes in, and the person is in the physical custody of that facility. So they've come in for an evaluation, they've come in on an order to apprehend, they've come in on a 1013. Any of those things could have happened to bring the person there. So first, the facility itself has to determine there's a need for outpatient treatment. And then if there's outpatient treatment available for that person might need to be transferred to another facility. The person has to be evaluated by this facility within 4 hours. And within that 4 hours, you have to make a determination for outpatient treatment. If it's determined they need it, then at the same time, the facility is supposed to prepare an individual service plan for this person and make arrangements for interim outpatient treatment. And they're given notice of the time and the place and the address and that sort of thing. And the patient's also told if they don't show up for this interim outpatient treatment, then they may be picked up and involuntarily committed for evaluation. If the person is discharged because the facility they first went into can't provide the outpatient services, then the other facility has the responsibility for filing the petition in the court of the county where that person is located. So they file a petition that says this person needs involuntary outpatient treatment because they meet this criteria. The petition has to include a copy of the report, the plan, the address to where the patient was discharged. They'll have personal representatives. The patient is served with this. The patient can waive a hearing. And the court can actually order an outpatient treatment just based on the ISP that's submitted with the petition. But if the hearing isn't waived, then there's a hearing that's held, and it has to be no sooner than 10 days, but within 30 days after filing the petition.
Sarah, I hate to interrupt. I just have a question. How many people are subject to this particular system in any given year, say in the last 5 years? Do you have any data on that?
I do not have data on that. The state hospitals do sometimes, and Judge Hargrove is on this. She might be able to answer at least for her court, but I think in her last presentation, she said she did not see these. They're very, very rare. Columbus, because they've just been the renegade of the state and have pushed forward with trying to make an outpatient treatment program there. They have had some of these petitions over the years, but primarily, unless it's going through the forensic side or a few rare cases where the communities have really pushed to develop a program, it's non-existent. And
So we have an elaborate legal process, but no participants.
we have an elaborate legal process. We don't have any policy at the moment. I know that it's being worked on from DBHCD even to cover this. We have policy to cover inpatient, but we don't even have any policy that covers outpatient commitment of this type. So
I'm sorry I interrupted you. I think you read
no,
the
that's
slide.
an important point. So after the court gets the petition, that you have to provide to the patient or the person notice of the hearing, notice of right to counsel, the individualized service plan, the patient's representative can have a copy of the service plan. They might have to have a guardian ad litem appointed if they have no representative, and that the patient has the right to be examined by a physician or psychologist of their own choice, and that they can waive the hearing. But what most often happens, and I can say I have never had a person go through an inpatient proceeding that I didn't have to appoint an attorney to represent them. Most every patient is going to have a court-appointed attorney as opposed to a hired legal counsel.
How many of these hearings have you had?
I probably have inpatient. I haven't had any outpatient hearings that were independent like I'm referring to now. So I have never had an outpatient hearing that was initiated by our community service provider.
How long have you been a judge?
10 years.
All right, thank you.
And I will say, I practiced law in this area 25 years before that. And during that 25 years, in the early days, pre-Olmstead, so pre-settlement order, we did have some of these hearings, but they were still pretty few and far between. Of course, I handled a number of cases at Central State Hospital, and that was a different sort of situation. But I would say in the last 15 to 20 years, there haven't been any.
All right, thank you.
So the court order, what can the court order? Well, we can order outpatient treatment for any period not to exceed a year. Again, the total amount of inpatient and outpatient treatment can't exceed a year total. We can also modify the order down the road. So if the ISP changes, they can come back in and say, we need to make some changes to the individual service plan, and we want the court to approve that. We'd have a hearing that would be scheduled to do that. We can have, if the person is non-compliant, the provider can file a petition back with, or a motion back with the court to say either we need a hearing because this person is non-compliant, or we need to have this person picked up for an evaluation because we feel they may need inpatient treatment. There are a couple of options for that. Also, they can ask that treatment be continued for more than a year, but that petition now, the way the code is set up, actually goes through the state hearing examiner's office. So there are state hearing examiners that make the determination whether it's exceeding a year. So that is not determined by the probate court. The patient, and I think it's important to emphasize this, the patient is given, their rights are protected. They have a right to legal counsel. Of the judges that I know that do this, and I can speak for my own court, we have competent legal counsel. We have training. I would never appoint someone. This code section is too complex and too convoluted, quite frankly, for someone to just come in and be able to represent someone with 24-hour notice. So we take a lot of effort to make sure the attorneys that are appointed by the court are skilled and understand what is going on and knows what the rights are and effectively represents their clients. And I will say, I have denied some cases because I had very effective attorneys. So the rights of the patients are very important, and we try to make sure those are all emphasized and are kept. So that's, in a very quick nutshell, how the process works. And from beginning to end, it's really a 30-day process or less. But there are so many ways that we could use this process to reduce the revolving door in jails, prisons, crisis units, emergency rooms. When I started thinking about all of the touch points here, we've talked about the forensics part of this. We've talked about jails. We've talked about prisons, but we also have a crisis within crisis units. I had a case just today where I was going to send someone who is a patient at Middle Flint, and I was going to send him back there because that's where his doctor is, except they are in an indefinite diversion. They're not taking any crisis patients. So I had to send him to River Edge instead. Not that he won't get the treatment he needs, but doesn't it make more sense that he go to where his doctor is? So the crisis units and the emergency rooms, and I think we're going to hear, we've already heard some about the emergency rooms in all types of hospitals. So we know that these are all crisis points. So we've already established through 1013 a pilot program for assisted outpatient treatment. And I'm not going to go through that, but for those who may not be as aware of it, it is a community-driven intensive program to help persons that need outpatient treatment get that treatment, initiate wraparound services like stable housing and getting their medications and doing all these things that these people may not be able to do on their own. They might need to initially have court intervention or commitment through this outpatient treatment commitment process, but the idea is to get them stabilized to a point where they can do this on their own. But we need to focus as well on the impact we could have on our largest mental health provider, our jails and prisons. Diversion programs from criminal to civil commitment. I think those of us that have been looking at this, they seem to be popping up everywhere. And I agree with Dr. Bailey. We have talked about this. The starting point is very logically with misdemeanor offenders. I'm suggesting, and Dr. Bailey and I had talked about this, that we establish a study committee made up of the key stakeholders that Dr. Bailey mentioned, and maybe even some others, that can investigate and create a structure for a type of project, a pilot project of some type for state and or superior court judges and courts that will utilize an early intervention diversion program in the misdemeanor area that will shift from criminal to civil.
Great
So
idea.
we take the burden off the criminal and we take the stigma of being convicted or going through that process. And I think this all dives perfectly with the Familiar Faces project, receiving assistance, treatment, a chance to break this cycle, a reduction of population in jails, crisis center, emergency departments. We reduce the overburdened state forensics department. I asked Dr. Bailey yesterday about a case I had. I had a misdemeanor, simple battery. It was a guardianship case for me. But when I got involved, he had been discharged after 3 years in Central State Hospital trying to restore competency. He could have pled guilty and served an entire year if he could have pled guilty. And
I
he
hear
would
that
have
story
out.
time and time and time again.
Absolutely. And that's ridiculous. Now we're dealing with him on the other end, but he shouldn't have been in the criminal justice system for that long. So I think we can find a way to do a collaboration between the courts, which would be a great way for all of us to work together, but we could do a collaboration between the courts and we could utilize the statutes we have in place for the most part. We might find that there are areas that need to be tweaked, but I think we could come up with a good plan that would utilize what we already have. And I think we could find the resources to do this because this is critical. And if we are reducing the jail population, if we were reducing the burden on crisis centers and emergency departments and the forensics, we ought to be able to create some funding somewhere for this. And I know that's always the key, but we have the tools to effectuate change. And I think our challenge for all of us is to continue to think outside of the box and change our approach. And I've really thought a lot about this from crisis intervention and management and arrests for mental illness, because an arrest for someone doing something because of a mental illness really is a crisis intervention. You're stopping him from doing it by arresting him or she. And we need to look how we can take those and turn them into more long-term healthcare management for those persons that are suffering and have been suffering from severe and persistent mental illness.
Wow. Well, that's really very interesting, very innovative, and something that I hope that you and Dr. Bailey will take on because it could really make a tremendous difference for just a huge population of people that need this care and this innovation. Dr. Bailey, anything you want to add to what Judge Harris has said, since you're on the subcommittee now?
No, I'm good. No, I think we all share. I think we all share, judges, sheriffs. I think everybody thinks the sooner you can get people out of the system, the better. And, when people are at low-level crimes, that if we can get them out of the system, jail is no place for them. I think everybody agrees. It amazes me when you talk to state court judges, even prosecutors are thinking the sooner you can get people out and get them treatment, the less likely they're going to go further in our system. I just think there's a consensus.
Well, this is exactly the type of thinking that Judge Stephen Leifman out of Florida has been doing for the last couple of decades. He's part of a project called the Equitas Project, which is the national initiative of Mental Health Colorado. They have published a paper here in August of 2022 called Modern Legal Processes to Support Clinical Intervention for Persons with Serious Mental Illness and Pathways to Care, a roadmap for coordinating criminal justice, mental health care, and civil court systems to meet the needs of individuals in society. Judge Leifman will be presenting on the findings of this project, which started in May of 2019 and continued through June of 2022, and the type of interventions that are being proposed by Dr. Bailey and Dr. Harris are he would very definitely think are appropriate and out of the box thinking and the type of innovation we need to better treat people. And in particular, he would see that this is something that fit into his pathway number 2. What I want to thank everybody who is continuing to show up for these meetings, for being here. It's just, it's really gratifying to see your continued attention and support for this work. On October the 11th, Dr. Leifman, or I should say, I call him doctor, you might as well call him doctor. He knows as much as, anyway, some do. Judge Leifman will be here. He'll be able to answer all questions. He'll present his alternative approaches to managing this intersection between the criminal justice system and the adult mental health system, the involuntary commitment system. And I hope that none of you will miss it. I hope that you'll become prepared with your questions. I've already circulated his 59-page report, and please take the time to become familiar with it so that so that we can all kind of talk together as colleagues and try to find out if there's a way in which some of this is applicable to Georgia. So I want to thank our presenters for being here. Does anyone have any other questions before we start to close it down? Hearing none, thank you again, Sarah and Karen, and we'll see you all soon.
Thank you.
October
Take care.
11th.
Thank you.
All right, bye.
Bye-bye.
Great job, ladies.
Thanks.